So now for a quick syllabus overview. So you might have already seen the syllabus. If you have not, then please download this particular syllabus. Recent syllabus version is January 2023 from your NCA website. So here they have given, the scope of exam, scope of this particular subject, what is there in the subject, and what they are expecting you in the examination, that is being mentioned here. Also, in my NCA Medici um, channel, I have in detail discussed both of these. You can watch that also. But anyway, in very summary manner, I will tell you again. Now, these are the chapters. So, how you have to divide is by parts. As I told you last time, also in the group, I told you read part one, watch recordings of part one. In part one, you have only two chapters. Okay. So, part one, we have two chapters. Part two is with respect to distribution of legislative powers. We call it in short form, I will be referring it as DOP, distribution of powers. Okay, DOP questions. If I say DOP questions, then that is from these chapters. Okay, so that is federalism, judicial review. So we have 1, 2, 3, 4, 5, 6, 7, 8, 9. 9 chapters from part 2. Okay. Then from part 3, we have entirely part 3 is consisting of 5 chapters and it is dealing with Aboriginal rights and constitution. What is the relationship between Aboriginal rights and the Constitution, how it is protected by the Constitution, and of course, in other chapters or other subjects also, you might have already dealt with a few of those. Section 35, 25, you might have seen the reflections in your administrative law, very smaller portion was there, and in criminal law, you will be seeing certain charter rights, right? So all these certain topics or certain case laws might be repetitions for you, but I would request come up with a fresh mind and forget what you have learned, and we have to start from scratch with respect to what we should know about Aboriginal rights in constitution. And of course, those who are writing foundations or preparing for foundations on the side, for you it is going to be the basic. Okay, these Aboriginal rights and constitution, what we cover here, introduction, Aboriginal rights, Aboriginal title, treaty rights, duty to consult, these are going to be your foundation, like very basic. Then in foundation subject, we are going to in detail deal with lot of articles, case laws and all in depth. Okay, this is going to be in comparison, I'm just telling you, this is 25%, that is 75% of Aboriginal. So, coming back to just your constitutional law, part 4 is dealing with entirely Charter of Rights and Freedoms. So, in the materials that I've shared you, I am also yeah. So in the material that I've shared you, you have syllabus copy, Bare Act, Charter of Rights and Freedom also. So if you have a printout of this, it will be better because of course they are going to NCA is going to test you on only section 7, 15, then 2A and 2AB, and also we are going to deal with the section 1 and 32, 30, 32, 33. Also, you're going to deal with 25 with respect to your Aboriginal rights. Okay, so these are the charter rights that we are going to deal with respect to constitutional law exam. But this page is going to help you in all the NCA exams. So it is better to have a printout of this. Whenever that charter related lines come in your exam, you're going to it is going to be helpful if you have this particular charter sections with you. Of course, these are already covered in your if you have the Bare Act of your constitution, Bare Act if you have, then these are covered over there. But still, even if this is not compulsory for you to have, okay, this printout is not compulsory for you to have, but I have shared you because in online it was quite difficult for normally to find only English version everywhere. Easily I was able to get the PDF version of any Bare Act that was both in English and French. And if we are able to, if we were going to take a printout, it will be a lot of like half page entire set, it will be waste, right? So that's why I've shared you the English version, and also for your reference if you want to read any of the sections in detail. So this document has both 1867 and 1982 acts. You might have already watched the recordings. You know that there are two constitutional acts, right? So 1967 and 1867 and 1982. So this particular document is consisting of both of those Bear Act versions. Okay, so that is your Bear Act and Charter Right. Yeah, so this is what I meant by saying, four parts are there in your syllabus, and in every question paper, at least three part will be coming. And most of the time, we have seen out of four parts, they will be giving questions on three parts, and one will be left out. Okay, so but we don't know what is that one part. It could be it could be DOP that they left out. It could be first part that they left out. So it's up to them. If they, but at least they will be giving three parts, right? So that is with respect to how they are giving your exam questions, how they are picking exam questions. But from our side, for our 100% preparation, we should have, for that purpose, we should complete entire four parts. And as and when we are going in depth with each and every chapters, keep in mind that which part it belongs to. Okay, if it is federalism, of course, it is nothing but DOP only. And if it is dealing with the judicial review and principles of interpretation, here principles of interpretation, we are going to deal with paramountcy, interjurisdictional immunity, ancillary powers, and all. There only it will come. And a major point in your DOP lectures are property and civil rights, that is coming under 9213. 9213, property and civil rights, trade and commerce, peace, order and good government, criminal law. These are the specific powers given to either the federal government or the provincial government. Okay, so these are the sections. So 91 usually 91 deals with the rights of the federal government in order to powers of the federal government to make rules, and 92 deals with the provincial government's power to make the rules on certain subject matter. And usually students miss out is this here. Even though 91 and 92 is important, like more focused on independent chapter, they have taken one subclass, right? Even the opening words, power, opening words also they have taken as separate chapter. But usually students miss out on these. 91 to 95 you are supposed to read, not just 91 and 92. Under federalism third chapter, they expect you to they expect you to understand and have a clear understanding of 91 to 95, all the sections. Okay, so these sections you should be referring to your Bear Act, and anyway in the class we are going to deal with it, and in the recordings you might have seen or you will be watching it. We'll be dealing with each and every sections under this, which are relevant for your syllabus. And also we will be taking up a few concepts like from your Bear Act itself. Okay, but I seriously suggest you that now you have time, you are preparing for your consti from now onwards, so have a glance at your Bear Act as well. Read it, whatever the sections that you see here. See here, Part 5 of 1982 Constitution Act 38 to 49. Amending procedure we have seen, right? Even though in the class notes that I have shared you, those are only the relevant paragraphs or relevant portions or summaries. Okay, that's how you're going to write in the exam. But that doesn't mean you should only read that much, right? So that is sufficient. But I'm saying if you read from the Bear Act as well, it is good. And here you can see that what are they expecting you to know with respect to each chapter. in chapter 1 they only have one case, reference ray secession of Quebec. Okay, only one case is there. And in each of the chapter they might not have a case law, but there will be provisions that you need to know. So regarding amending procedures, we really don't have any case law aspect, but reference ray secession of Quebec will come there as well, right? It is going to influence because regarding amendment question was there in the secession of Quebec. So even though sometimes in the syllabus they might not give you in a clear idea, here and there they will be making you read the concepts. But in the class, what I have done and what we are going to do is that we are going to have a proper understanding of each and every topic, and wherever it overlaps, okay, we are going to deal with them in detail with respect to wherever it is going to overlap. So now, and from exam point of view, Aboriginal rights and constitution, very, very important. This is important in general also, but from exam point of view, this part is very important. All of these cases are very, very, very easy to remember also, because these are, certain situations that happened with respect to Aboriginal people. Very nice story like, facts are there. So we can discuss them, we can remember them. Uh, Really speaking, if you prepare really well, you watch all these recordings, and we also discuss in classes, then you really don't need to refer to the materials on the day of the exam. To that level, you can be confident and be ready for the exam. But still, we have supplementary material copies. Those are sufficient for you to take printout. So now, with respect to charter also, charter questions, I have seen lot of times they ask repeatedly charter question. Okay, charter question related to 32. This is related, very important with respect to your foundation as well. And um, section 2A and 2B, in every paper they ask section 2A and 2B. These are easier ones, but with respect to each case, they provide a certain situation and they question you. Do you think here 2A is violative or not? Okay, so that particular, in that particular fact, in that particular context, and also we should go back to the year. In 2004, Supreme Court of Canada set this particular, ratio of that particular judgment, what we are going to learn. That came in 2004, not in 2024. Today we are in 2024, 20 years before it happened. Also, whenever you're reading, 1989, you might not have, you might not relate.
Vidya,
Yes.
hello,
Yes.
hello.
Yes, Varsha, we can hear you.
Your voice wasn't audible.
Now?
Yeah, better.
Okay. I think network issue. So here, with respect to, when you are, when you are not able to relate to a particular ratio of a case, just look at the year when it was given. Okay, that helps us to understanding. Okay, in that year, that was the case, and then in the recent development, you can see 1989 case they have given, 2005 case they have given. Sorry. Yeah, then 2013 case they have given. So you will see the development of cases, and some cases they are only asking you to, uh, uh, you know, understand certain aspects, or it might be giving out some sources, some factors, some tests. In constitutional law, you are going to see a lot of tests, and in each cases there will be two-part test, two-step test, but they are very topic specific. So if you see 2B, if you're writing answer for 2B, go to this particular chapter supplementary material and refer to the test given under those cases. Which case is having event or is having the test, and other two cases are given for you to understand certain situations. So test is given under this. You are not supposed to delve into the facts of this particular case, only test. So test is important. So that's about just I wanted to say why these case laws are given in a very old case laws also they give you sometimes. And uh, okay. Also pay little more attention to the recent cases. I know 2020 is not so recent. I think there is one more case with respect to little more recent. Okay. If in case any cases that you're seeing after 2020, that is to be read with little more caution and give little more importance to those facts. Because it has been the practice of NCA in generally in all the subjects that they give facts related to or similar to the recent cases that they have added to the syllabus. So you can connect with you can actually look into your question paper and relate to what you have learned, right? So that will be always easier. And as I was discussing in the starting, that as per the schedule, we are going to discuss each and every questions, topic related questions in our upcoming classes, so that you have an understanding of how and what type of question will come from each chapter, that chapter related. And in these practice, by the time you are dealing with 100 marks of paper, you will be able to identify which chapter question it is. That is the very very important first step. Okay, now I will take up a few questions with respect to class 1 chapter 1 and 2 recordings that you have watched. I wanted to ask, are you able to understand any difficulty in understanding and the course materials that you have seen? With that, you have any problem? I'll just show you in very brief. These are the materials. See, I have shared you even these materials, DOP table, practice questions, and all those things. Don't worry about these. Just make a list of documents like which are named chapter 1 and 2 supplementary materials. Those are the one you have to take a printout of. And as and when we are dealing with the classes also, I will tell you in detail what you should have, what you should, what are there. You can just refer on soft copy. The question answers and all, now you don't take a printout. Okay, I would like you to take printout and make a spiral binding or book binding, whatever is comfortable for you, of these ones chapters. Each chapter you will see this material, these material, chapter 1, chapter 2. You have, this is named as supplementary material in your mail. Okay, you can take a you can download them and you can take a printout. And in the class also, I have opened the same document and I have highlighted. Okay, and I'm not sending you highlighted versions, because when you take printout, if you want to highlight it in a different manner, you can do it. So in the class, I have highlighted the relevant points. And as and when I didn't want you to, have a different PPT in the class. Then you read, different material. Then you practice. So different thing. Let us not do and confuse ourselves. Even though everything is talking about the same thing, little here, little there, little another place, not needed. Okay, we are going to read from the same material, write answers from the same material, study from the same material in the class as well. So you have an understanding, even if you don't read on your own. I don't trust students, they sometimes don't read on their own. Okay. So for you to be a little lazy also sometimes, I'm allowing you that for now. So in the class itself, I have opened this same material and gone through. I also somewhere if spelling mistakes are there, that has been corrected in the class itself. So when you're watching the classes, make certain highlights as per the directions given in the class. And any minor mistakes are there, that has been corrected or discussed in the class itself. Okay, now you can tell me, we have, yes, we have Rishabh, Varsha, Yashika. You can tell me, when you were going through the lectures, was there any difficulty in understanding any, do you want any additional supports?
Vidya, I
Yes.
didn't have any doubts or lectures, but I just want to understand from the exam point of view in chapter 1, which talks about sources and nature, what are the possible relevant questions that can come?
Mm. Okay, from sources.
Yeah.
Your first chapter is a theoretical topic, so very rarely, but the NCA has always been, kind of notorious in giving question papers, right? So we can expect, least expected, but even if they want to give question on this particular chapter, they will give you essay writing, short note questions, okay? Because there is no way they can do a very more than 10 marks might not they might not make it, but they would connect this particular chapter with another bigger concept like DOP. Along with the DOP they can connect this and they can ask about ask you to expect you to write a smaller concept which is mentioned in your chapter 1, like section 52 clause 1. You might be using this particular paragraph while writing answer in some other chapter. Okay. And with respect to this, like three major changes that happened, and this is very basic understanding, introduction to your entire Canadian constitutional law. There were two constitutions, and what were the changes and what it gave. What was the benefit of this particular change to your to Canada? And Canada is a confederation. It has 10 provinces. All those general things you should know. It is for your understanding. Basically, the exam directly it might not come, but in your exam wordings now, questions paper will be sometimes little too big. That time, in order to understand the question, also we need these background context. So from that point of view, we should read. This is very theory. Any other questions?
No. So what I understand is, Vidya, it's a theory type chapter and not very exam specific questions will come.
Yeah, even if they ask also, they might ask you to write a, short note on the amending, short note on confederation or section 52 important supremacy clause, or they can ask you by BNA Act, BNA Act and what is the importance of BNA Act? See, British North America Act was there, right? So now, what was the reason for introducing a new Constitution Act of 1982, and why did they not remove entirely 1867 Act like that? If I was framing the question, if they wanted me to make a tougher question, I would have made like this. So you should expect like that. Even if they gave that question, how would you write? What is the importance in the present day of the older act, BNA Act? Now they call it as 1867 Act. Anybody would like to answer? What is the importance of 1867 Constitution Act in the present day? Why it is still there?
Uh, it is still there because I think it talks about like we mentioned, section 91, 93, those sections, an important aspect of federalism and DOP aspects.
Yes, yes, that is the answer. Because in the present Constitution Act does not have to talk about those because it has already been covered under 1867 Act. Okay, and the basic structure like with respect to your DOP talks about who should do what work and division of powers and basically with respect to lawmaking powers. So it has been clearly divided into federal and provincial government, and it is also kind of respect that they pay to the colonist, to the British, the crown, right? So because okay, let me ask you this question. Rishabh is not supposed to answer. um, is Canada a constitutional okay, do you know what is constitutional monarch?
Constitutional monarch is when there is a
President
one
is the
single
pres
ruler. Like,
where the president is nominated or elected by UK Parliament.
President is
Uh,
elect. Um,
Governor, I guess the Governor General of Canada.
yeah, Governor
He
General.
is
You're right.
represented. Yeah,
Hmm.
Governor General is elected by the UK like Parliament or Queen.
Mm-hmm. He's representing the Queen, right? Yeah. Now crown.
Right.
Queen is no more, so now king. Instead of saying that, I just use crown. So now Governor General is the person who is representing the crown, and it is constitutional monarch because Governor General represented the crown by the crown is the head of the state. Okay, and who is the head of the government? Head of the government is Prime Minister.
Prime
Okay.
Minister. Right.
So this is basic concept. Again, I have sent you one more document with respect to which is named as mm, yeah. What do you need to know about Canada? Okay.
Right.
Yeah, so this one you can just have a read through. So here it talks about what is the constitutional, unwritten parts, written parts, and what is Canada's constitution in very general sense. Okay, so this you can read, and also there are some supplementary materials which come from your foundational material. In the syllabus copy itself, they have they have added a few links with respect to Canadian legal system. So if you read them, it is going to help you in understanding much in detail with respect to constitutional law as well. Okay, so now, yeah, so you watch the class recordings. If you have not watched 1 and 2 yet, please watch them before our next class, because next week, Sunday, we are going to deal with chapter 1 and 2 summary, and we are going to discuss the concept. I'm going to open the chapter and discuss the concept once, but mostly we will be focusing on practice questions. Okay, any doubts you can ask then also, and in between you are watching any class recordings after chapter 2 also, you can continue watching them, watching the other classes. So if you are getting any doubts with respect to specific to any chapter or any case law, you have doubt on the concept, material that I have sent, so you can approach me on WhatsApp, you can send me a voice note or a text message. I will try to solve that within 24 hours time, and if it is requiring a further discussion, then I'll get on a call with you. So now, are you ready for looking at a sample question on how and learning how to write an IRAC answer for constitutional law?
Yeah.
Yeah. So see, IRAC writing is an art. It is not that before in law college we might have used this IRAC writing method, and in other subjects you have already written other subjects and you have cleared, and you have a basic understanding of what is IRAC. Okay, but again when coming to constitutional law subject, there are few changes that you have to do in writing an answer in each subject. Okay, so that is the reason why I tell you, keep an open mind, and always try to adapt with each subject. We have to add on to our skills what we know. Okay, so there is this one sample paper, NCA sample paper, that is given to you by the NCA itself in their NCA website. It is uploaded. Out of that, there is one question that is related to your amending procedures. So as you have already watched class recording of amending procedure, that is why I have chosen this particular question to discuss today, so that you have familiarity with the concept, because we have not started with the other topics, so you can relate to what they are talking here. And this is a question pattern that is prepared by the NCA itself. Okay, so you can see the similarity of the wordings, how tough it looks, how easy it looks, you can get an idea. Now, let us read the question first. Varsha, would you like to read the question?
Yeah, Vidya, I can read.
Thank you.
Okay. Shall I start? Yeah. Bill C-22, currently before the House of Commons, proposes to change the formula in the Constitution Act of 1867 that determines the number of seats each province will have in the House of Commons. The existing formula set out in Section 51 of the Constitution Act allocates seats based on representation by population or the principle of proportionate representation. Although exceptions are made to ensure that the number of seats to which smaller provinces are entitled does not diminish over time, because of these exceptions, if Section 51 were not amended, the provinces with the fastest growing population, Ontario, BC, and Alberta, would see their number of seats in the House of Commons fall below the number they should have been solely on the principle of representation by population. Bill C-22 proposes to put up in place a revised formula that will better reflect the principle of representation by population or proportionate representation. It does this by altering the formula so that after the next decennial census, the number of seats in British Columbia and Alberta would be increased so that the proportion of the seats in House of Commons will match the proportion of the Canadian population. Under this formula, Ontario's proportion of seats would increase as well, but Ontario's seats would still be significantly less than the number of seats necessary to match its proportion of the Canadian population. The federal government is taking the position that Bill C-22 can be enacted by Parliament alone without the consent of any provincial legislature. Members of the opposition have argued that Bill C-22 cannot be enacted without the approval of at least 7 provincial legislatures, representing at least half of the Canadian population. What provisions in Part 5 of the Constitution Act 1982 could be cited in favor of the federal government's position? What provision in Part 5 could be cited in favor of the opposition position? In your view, what is legally the correct position regarding which amending procedure in Part 5 of the Constitution Act 1982 is applicable?
Thank you, Ashok. Now I am going to ask a question about this to Yashika. Yashika, you have watched amending procedure class, no?
Yeah, I watched it.
Okay. So can you identify here what exactly they're pointing you to, like what they are expecting you from you to write in the answer?
I need to read the question again.
Yeah, so that is the thing. So question is so long, and this is a very average length of the question that they are going to ask you, right? So how are you going to, read the question again and again? That should not happen. So once when we read, that time we should understand every point, so every key elements out of that. Read it like a story, remember it, imagine it in your head, whatever it takes, but have that understanding of each and every paragraph or each and every line. Once you understand, then go ahead, okay? But in order to pinpoint what topic it is, always go to last paragraph. This is one of the trick that works in your constitution exam. I'll tell you in which subject it does not work when we are dealing with that, but in consti it works 99.9% of the time, and it's a good risk that we can take, right? So even if it doesn't work also, we'll come to know right away. Okay. See, if you look at the last portion, there are few question marks given in the question. So last paragraph, few lines, it is having certain question marks. Focus on these questions. What they are asking, what provision in part 5 of the Constitution Act 1982 could be cited in favor of the federal government's position and on the opposition side's position. So they are asking you to write cite. So if they are asking you to explain, then only explain. Okay, this question actually was for 20 marks. So if a question is for 20 marks, then you are not supposed to deal like in write the answer for like pages and pages together. You are only supposed to write answer which is around like almost 2 pages. Two pages is more than enough, like 10 marks per page, like that you can count. Okay, in a word page I'm talking about. Of course, in the exam day, you will not be having that entire big screen page, but you can see there, like when you are practicing now in the word, you can see in one page in font with font 12 how many word count is happening. Same you can then use that particular calculation you can use and on the day of the exam. Now, with respect to the question, in the last part, they're asking, in your view, what is the legally correct position in regarding which amending procedure in Part 5 of the Constitution Act is applicable? Now, first, what they could support takes a position. They are supporting. You should just cite. You should just say, this is the one. This section is the one. For the opposition side, you should just cite. But this one, you are supposed to provide your opinion, right? In your view, what is the legally correct one applicable? So you have to talk a little more about, like, at least at least 4 to 5 sentences you can write on this one also, because you are choosing one out of these, or you're choosing some other provision. So basically, it is talking about which provision is which type of amending procedure is to be used for the amendment of this particular bill that is before the before the parliament. Now here, Bill C-22 is currently before House of Commons. Before whom? We don't want. But what it is proposing, we want that, because with respect to amending procedure chapter, you might remember part 5 of the Constitution 1982, your older version of the Constitution, that is BNA Act, that did not have amending procedure. Okay, now the amending procedure, whenever it comes, your head is going towards 1982 only. Only with respect to DOP, you refer to the older Act, 1867 Act. Okay, that is basics. Now, with respect to your amending procedure, there are total 5 amending procedures: general amending procedure, unanimity procedure, some but not all provinces procedure, the federal parliament alone procedure, each provincial legislature alone procedure. Even if you have not gone through the video lecture completely, at least by looking at it, in the fact, somewhere we read that federal parliament is saying something with respect to they can do it alone. Where is that number, sentence? See, the federal government is taking position that Bill C-22 can be enacted by the parliament alone without the consent of any provincial legislature. So they are saying federal parliament alone can do it. So for this particular question, where they're asking which particular provision could be cited, what provisions in part 5 could be cited in favor of federal government? Direct answer is there here. Federal parliament alone can do the amendment under section 44. Just that, section 44. You are able to locate your answers. Then what you're supposed to, this is before you start writing the answer. This is the workout that you're to do before you're starting to write the answer. First, you see what is the major topic. You have understood the facts. You have seen what is the major topic. Open that particular supplementary material. Okay, chapter 2, it is consisting of chapter 2. I have opened the chapter 2. Then I'm focusing on the main question that they are asking. Federal government side, I remember seeing this in my class. So federal parliament alone, section 44, I'm just pointing it out now. Okay. Then what is the opposition? Opposition is saying something, right? Members of the opposition have argued that Bill C-22 cannot be enacted without approval of at least 7 provincial legislature representing at least half of the Canadian population. Now, this is the opposition's view. Okay, this is the federal government's view, and that is the opposition's view. Now, two different views are there, right? Two different views are there, and they are asking your view as well. They are asking your view with respect to what do you think is the proper applicable legally correct position. They're asking legally correct position, not like only your view. Okay, you cannot give your personal view. Okay, I think it is easier if they go with respect to only provincial parliament alone procedure. No, you can't give that particular opinion unless they are asking specifically. Okay, you tell your personal opinion. They don't. So here they're asking legally correct position. Yes, Varsha.
Vidya, one doubt. Can you just tell me the second part? What provisions in part 5 could be cited in favor of the opposition provision? So that will be provincial government, right?
No, they are not specifically saying ki it is the provincial government is the opposition party. Opposition party could be anybody. We are not going to, of course, some province. It could be some
So
of
what will
province
we
might be.
cite here?
Yeah, we will cite. I'll tell you. So
Hmm.
here the hint is towards seven provincial legislature. Seven provincial legislatures representing at least half of the Canadian population. So seven, half means 50. 750 rule. Does it recall something?
General amending procedure, section 38.
Yes, yes. So general amending procedure, section 38. In our class, we have in detail dealt under section 38. It talks about seven provincial legislature having 50% population of all the provinces combined. Whoever comes, that is two-thirds of the provinces, which is constituting seven, because total there are 10 provinces. Total number of provinces in Canada are 10. So two-thirds becomes seven. So we call it as 750 rule. Okay, so directly they're not going to tell 50% of the population, two-third of the provinces, and also it is not just this much, right? By resolution of the Senate and House of Commons, and so this one is also required. Do not forget this part. Okay, so rule is this entire bold, highlighted. This entire portion is the rule. Okay, so you have to cite section 38. Section 38 is talking about the procedure. Now, that much this is the procedure, but again, which subject matter it is? Under section 38, in order to do general amending procedure, in order for this particular general amending formula to apply, there has to be certain subject matter. In your section 44, directly it is given. For section 44 only, they have given the subject matter. Okay, under section 44 only, they have given the subject matter. If you see here, Parliament may exclusively amend the Constitution of Canada in relation to Executive Government of Canada, Senate and the House of Commons. So in our question that we had the word of House of Commons. So you can see, yeah, here something is mentioned with respect to House of Commons, and under section 44 only they could do that, anything with respect to House of Commons. Exclusively amend the Constitution with respect to House of Commons. So that is also dealing with, our question is also dealing with a particular amendment to the House of Commons, proportional representation in the House of Commons. So that for that particular part, to that particular extent, if the federal government is arguing, then they could quote or they could cite that particular section. And on the opposite side, opposition, whoever is there, opposition is saying this particular procedure only should be applied. So for that particular, their argument's sake, you can say that they could do that under section 32, but your answer should not be ending there. You should prove that this is coming under subject matter. Subject matter is dealt under section 42. Section 42 specifies that amendments with respect to the following matters in particular must be using the general amending formula. So you have to figure out now our question ka jo subject is there here, what they are trying to change. Here it is proposing to change formula in Constitution 1867 that determines the number of seats in the each province that will have in the House of Commons. Province, how many number of seats will be there by the province in the House of Commons? But more specifically in para 2, they are telling exactly which part of that particular section, which section they're amending, which sections part, what part they're amending. So here, let us see the facts again. I know in the 42, it's very clear, very, very easily they have mentioned, in the first part itself, you can see that. But I wanted to go back in the reading to question first, because here they are talking about, yes, Varsha, you have a question?
Vidya, sorry, I don't know, I'm not able to what to say, process and relate now to the second part of the question. First one, I understood it will be federal parliament alone, but the second aspect after that, what you said, I'm getting confused a bit.
Yeah, so that's why we'll read the question again. Okay, before going to the answers, that's why I came back to the question. Here in the question, what they're saying, the existing formula, see, amendment means what? Whatever is there, they're changing, right? They're changing, making changes to that particular thing. So first, with respect to amending question, no, they will always give what is the they might sometimes give you, what is the existing formula and what is the existing provision and what is the amending procedure, amending provision. So which will help you what it is making, what is the usefulness of that. It will be helping you to find out what topic they are talking about, what subject matter they are talking about. Then only we can figure out under our different 5 methods we have. Under each method we have subject matter they are dealing with, right? We have under each topic the subject matter they are dealing with. So in order to apply, we should know, now we should first see in our question which one was the topic. Here they are saying that the existing formula set out in section 51 of the Constitution allocates seats based on representation by population. That is the present rule or the principle of proportionate representation. That's what they call. It is a correct present provision, that is section 51. So we now come to know from this line that they are dealing with the amendment of section 51. Further, although the exceptions are made to ensure that the number of seats to which smaller provinces are entitled does not diminish over time. So there is an exception also. Representation by population is happening. That means population is more, representation is more, right? Representation by population. It is directly proportional. Okay, that was the present rule. But they have exception also, because bigger the province, larger the representation in the House of Commons also going to be. So in with the time, smaller provinces, what they will have, they will lose more seats because they are smaller in number. They will lose more seats in the parliament, in the House of Commons, because of this particular rule. That is why there is an exception also in order to save them. Because of these exceptions, if section 51 were not amended, the provinces with the fastest growing populations like Ontario and Alberta would see their number of seats in the House of Commons fall below the number they should have, based solely on the principle of representation by population. So that is the current provision. Now what do they want to do with respect to that? There is a provision, formula, representation by population. For that, exception is also there with respect, because they have also given the purpose of that particular that particular exception. What is the reason why they have put the exception? But that everything might not be important for your answer writing, but we should understand what they're talking about. In the next paragraph, they say that bill now your current bill is proposing to put in place revised formula. Whatever formula is there, they want to revise it. That will be better reflect the principle of representation by population or proportionate representation. It does this by altering the formula so that after the next decennial census, the number of seats in British Columbia and Alberta would be increased so that their population, proportionate in proportion of the seats in the House of Commons, will match their population, Canadian population. So, under this particular formula, Bill's formula, Ontario's proportion of seats would increase as well. So Alberta, British Columbia, Ontario, everybody's seats will be increased, but Ontario seats would be still significantly less than the number of seats necessary to match its proportion of the Canadian population. So what they're trying to say is that whatever exception was there, they want to remove that particular exception. Okay, something to do with representation by population. That formula is there currently, exception is also there, but they want to change that particular, revise that particular formula. Now we understood what is the topic. They are talking about representation by population rule in the House of Commons. That is the gist of it. 2 paragraphs, whatever we read, it is talking about the amending procedure is happening on section 51 of the Constitution Act of 1867 with respect to representation by population in the House of Commons. This is what you're deriving from the entire question now. Now both sides are saying what they said that they can do it alone. Federal government, opposition is saying no, only you can't do. 7 provinces should come and 50% of the entire Canadian population should come for that particular amendment. Now the question is asking, what is your opinion also? What is legally correct position in your view? Okay, that much facts are understood?
Vidya, can
Yes,
you go
Vidya.
back to the question 1 minute?
Yeah.
So here, what provisions in Part 5 of the Constitution could be cited in favor of opposition's position? That is the amending, general
General
amending.
amending formula. Huh.
Okay, got it.
That is just,
I got it.
again, we are coming there only. So
Hmm.
question is understood. No, now we can, sort.
Yes.
Now we understood what is the subject matter, because under, even if you're saying that, see, the opposition is saying under section 38, general amending formula is only they are talking about. But whether that is confirmed as per your understanding, because they are asking, final question is what? What is the legally correct position? You are saying yes, they are talking about section 38. And these people are talking about section 44. But in your view, which one is the one? So you have to clarify. So now that they have already spoken about 38 and 44, first we will rule out that. Okay, that is my trick for you. So first we will rule out that this doesn't work. Then we will look for other things. Simply why to look for other, outside first and then come and rule out this, right? So either you can go chronologically, first general amending formula, 38, then go on to 41 and all those things. Either you can do that, or my trick is that always in the question only they have given the hint of two, right? Out of this, at least one should be applicable. And also when we saw 44, we had that particular House of Commons word there, and we didn't see exactly the House of Commons. We are yet to see, right, what is there in section 48, 42. So now coming to section 42, we are looking for proportional representation, House of Commons, these two words. Okay. So first only, luckily we have in the first instant itself. In the exam, don't expect this to be very easy. If it is very, well and good. But if you're having, difficulty in understanding, choosing, and if you have a hint, okay, here it talks about principles of proportional representation of provinces in the House of Commons. This is exactly the topic we are talking about in our question. So here it is hitting. Here it is the proper one, right? So proper, legally proper one, you can fix on that. But in the exam, if you have a doubt, then mark that and go ahead and see. Anything else 100% matches. Now this one is 100% match. But 44, just for example, I'm showing you, 44, they did talk about House of Commons, but there is no mention about representation by population. Whatever is having more, relation with the topic that is coming in your question, that is what you are going to choose for your amending procedure. Because subject matter should come. Either both the parties might be arguing about some one point, another point, okay? And also look for any other, provision is talking about this one or not. Here also you can see under 41, unanimity procedure also is there, where all the provinces must come, right? Unanimity means all the provinces must come. So here must assent to that. So here the right of a province to a number of member in the House of Commons is not less than the number of senators. But till here we see some sort of, familiarity. We see some form of familiarity with respect to this particular sentence. But what is more matching to our question? This one. That's why we are going to choose 42. Subject matter is specified under 42. That is why we feel 38 procedure should be the right one. But 41 also might be applicable, right? In your exam, when you're writing, you're going to rule out. You're going to rule out 41. Why? I will tell you. How? I will tell you. But um, whenever that similarity comes, how you are able to rule out what and all points you have to look for. Now, this is first part is that, you understood the question, pointed out which pointers you're going to write in the answer. Now that you're doing this for the first time, it's taking so much time. But later on, once you're well versed with the topics, we practice. Don't worry. In practice, we are going to deal with it very slowly. Very we might take lot of time. Okay, because we have to understand the concept. We have to identify the major topic, minor topics, and we'll be discussing, right? But in the when once we are done with all the topics, and we do continuous preparation, a practice paper answering method, everything will practice day to day. That time you will be having 100% confidence. But now it's okay, now it is, it's just a starting stage. So take your time, don't give yourself too much of hard. Okay, don't be hard on yourself. So here, now coming back to answers. So first you read the question, understand, okay, I have to talk about this concept, note it down on your supplementary material. I usually use a pencil because in pen we can't mark and all. It's simply because I'm not sure now, I'm just guessing now. So once I'm sure, I'll be typing the answers only. Okay, now coming to answer structure is having IRAC, right? So IRAC, I issue, R is rule, A could be application or analysis, totally your choice. Then C is conclusion. Now in red what I've written, that is a clue for you what you should write in this particular part. I is identifying the issue. In the issue part, it should be as plain and simple as possible. Don't try to make it too long. Don't try to make it too short and very vague. Be clear, be specific, what exactly here happening. Here, see the type of issue that is framed. And I'll show you exactly from where I've taken this from the question only. And in one thing, you be sure, in your answer, more than 45% of your answer material should be coming from your question itself. That is how they know. You might have seen in lot of feedbacks, or the mentors would be saying that don't copy, people are getting failed because of that boilerplate whatever they are sending now. So that is because they are identifying it very quickly, because you're not using the keywords from your questions, or sentences you're not using from the questions. 45, more than 45 actually. You can say actually almost 55% is your question only you're writing in the answers, but not as it is. I've seen certain few students writing in the beginning. Of course, I'm not saying they're doing wrong, but in the beginning, before knowing what students will start doing, see in the question so and so, so and so, so and so happening, they will give a summary of the question. Not required. Directly jump into answer writing in the pattern given. That is a very effective method. See, in the beginning, given I was not sure like how to frame the issue, what will come, whether I'm writing is correct or wrong. Practice makes you perfect. Okay. So at least practice makes you better, right? So that we can rely on, right? So here, issue issue is like a cherry on top. Okay, in your exam, how much mark it is there, don't ask me all those things. How much mark is there for issue, how much mark is there for rule. That division they don't tell, they have not given in the public, and I also don't want to assume it wrongly and tell you, miss guide you right on that point. But this much we can say, that rule and analysis and conclusion, of course, they are like kind of very attached with each other. And issues, most of the time students write different form of issue, different type of issue, but the crux of the matter should be same. You can frame it, I can say that Ram killed Ravana, and Vasha says that Ravana was killed by Ram, and Yashika is saying that Ram killed Ravana with the ban, right? So we all are writing, but who's clearer, who's more clearer? Yashika is more clearer. I also told the same thing, but I didn't say how. And Vasha also told in a different formation, but she also did not say how. Yashika told how also, who, whom, and how. Everything is mentioned there. So that's what, like, slowly we will practice that also, how much clear your issue will be. Here, what is the legally correct amending procedure to be followed or applied? Any word, one word you can use. Okay. So, what is the legally correct amending procedure to be followed to amend the exception provision to representation by population in Section 51, Constitution Act? Constitution Act, in bracket I've written CA, so that every time I can just write CA, because you wouldn't believe when this constitution will become constipation. Okay, in your answer, because you don't have auto correction. Okay, and every time writing this constitution, it will become something else by the time you are writing your analysis. So many times you're using this word, right? So you can short form everywhere. Even here you can do. Okay, so everywhere you can just short form it, so that it saves your time, also does not let you know write wrong words. They also check for spelling mistakes, and definitely when they open it in their Word, they will get no automatically. They don't have to do manually. They don't have to check that. So be sure about your grammatical errors. Don't make grammatical errors and spelling errors. That's why once we can be careful, then we can use short forms. But starting only you tell that from here onwards I'm going to use CA means Constitution Act. So be sure of that. I'm going to write from here on. So you're not going to say hereinafter refer to as CA. Don't have to do that. Okay. Just write in the bracket. They will understand. Now, you can see that a portion of this I've taken directly from this much I've taken from the last portion. What is legally correct position regarding which the amending procedure in part 4 of the Constitution applicable? So from here I've taken the first part, I've taken here from here. Second part, here what they have asked regarding which amending procedure in part 4 is applicable to what? So that's why I'm writing here provision 2. So what are they amending? Amending the exception provision to representation by population in 51. And that is from 1867 Act. They are amending 1867 Act. Don't be confused. They are amending 1867 Act, but amending procedure we are using from 1982 Act because 1867 does not have amending procedure. Okay. So that is why everywhere like they have used, you can see multiple times they have said Constitution 1867 two times. Okay, at least two times they've said. And this one they have said two, three times, right? 82 they have said two, three times. Sometimes they'll do that to confuse you also. You were reading different numbers, different names, similar names. They will repeat the entire sentence again and again. They wanted to read more now, like question only if they make it like longer and longer, chingam ke tarah खींच देंगे, so that you get उलझ जाओ आप उसमें. But we'll be smart. We'll be like, I got you what you're trying to do, but I'm not going to get fooled by what you're trying to do. Okay, we are going to be like that. Now that is the issue part. Now coming to rule part. Rule में क्या लिखना है? What you're going to write? Provisions, topics, topic line name or concepts name. Side heading you can write here. You're not going to explain anything under rule. Be sure of that. Do not explain anything. You're saying doctrine, case law, provision, whatever comes, that comes under your rule part. Do not explain. Nothing should be explained in your rule part, and as much as possible, do it in bullet point. Only rule. Don't bullet point your paragraphs here under the analysis or application. That is the first bad thing that students do sometimes. Okay. So I'm strictly telling you that do not bullet point your application, but only bullet point your rules because it looks neater. Okay, and I'll tell you, you'll get for writing in neat, in school also used to get that for writing in neatness extra points, right? Even here also, writing neatly helps you in two ways. If you're writing the correct answer, you're writing neatly, you're more likely to get cleared paper first. You're writing the correct answer, but even if you're writing the correct answer, you're written it in a wrong format, then they are not able to understand. There is no flow in your answer. You have not underlined or highlighted certain portions of the proper answer. You have not specified the rules like this. Somewhere here you're adding some rules, one rule you're mentioning here, additional rules you're mentioning in your answer. Those are the silly mistakes that students by mistake they do that, right? They have not practiced properly. That is the reason why that happens. So rigorously we are going to practice our different topic specific to topic. Once we deal with that particular topic, then immediately after that we are going to solve the question that is related to that topic. So that's how we will be practicing. Now just understand from the not from the topic specific. I'm just giving you the structure. So structure you understand. Okay. Even if you have difficulty in understanding, even though you have read the class recording, you have seen the class recording and read the notes, but still if you have concept related doubts, we will discuss that in the next class. We are going to do chapter 1 and 2 discussion and question answer practice there also. Now just understand the structure. So under rule, I am mentioning the federal parliament alone. Amending procedure you can also give here. Amending procedure applicable or amending procedure like that. You can give a side heading, then write these two. Not required. You can do that. It's not wrong. But I try to type as less as possible. Okay. So, but this much is important. Very important. Federal Parliament alone rule, which we have just pointed down, 44 of Constitution Act 82, general amending formula 38, 42, because subject matter is 42. Why I am not writing about 39, 40? Because it is not related to my question. That is one more thing that you're supposed to do. You're not supposed to write what is not relevant to your question.
Vidya.
Yes.
Hi, Kushag this side. I have a small question on this. So we do not have to expand the section. We just have to mention section 44. We do not have to write down the whole section in it.
Yeah, we are not supposed to write the whole section.
Okay, just the this is section of so and so, and that's it. We are done.
Yeah, that's it. We are done. Because it is an open book exam, they do not expect you to copy paste from your study materials. You're just supposed to refer, like from this particular section, and you can write why it is that in the analysis part we are going to explain why it is so, why it is applicable.
Okay, perfect. That's gonna save because makes sense because I was of the point of view that we have to write it and okay this helps a lot actually. Thanks.
Yeah, okay. So that is the thing. See, we are used to writing answers in a very different format. It's not this problem of students. Even I was under the influence that we are supposed to write this section talks like this, and this is the case law. That's what we are used to, right? So, but for NCA exams, that's not so, because in our exam that was okay because we were writing from our head directly, right? We were remembering everything and we were writing. We did not have open book exam. So here it is an open book exam. So if you are writing anything from your material, copy pasting, like for example from statute, from case law as it is, other than your whatever you have prepared or whatever I am giving you from there, if you copy paste, it is fine, because that is prepared material, right? Prepared material. They are not directly from a statute or case law. Only these two, that is what they are expecting you not to copy, is from case law, from the judgment, that is public, right? And then your bare acts, bare act sections as it is, you're not supposed to write for any of your subjects, NCA subjects. Now, coming to analysis part, even though you're not supposed to say that what is this section talking about, but one thing definitely you have to write, that why you're quoting section 44, because section 44 deals with so and so thing, same thing what we are dealing with in the incident case. That is what you have to connect every time. Every time, whatever reference case you're mentioning any section, then you have to do that particular connection point. Now, I always start my answer with respect to something general. Okay, here as I told you, they have mentioned 87 and 92, 1867 and 92 acts again and again. So I felt it is quite important here to catch them. Like even though you try to confuse me, but I will just make a sentence like this one to just poke you. So here what I've written: in the event of amending Constitution, whether Constitution Act of 1867 or of 1982, the Parliament or the provincial legislation must adhere to the amending procedure mentioned in Part 5 of the Constitution Act 1982. What did I write here? Even though we are amending 1867 or 1982, any constitution part, any part of the constitution under both of these acts needs to be amended. Amendment procedure is mentioned only under part 5. Even in the question also they have mentioned same thing, part 5 of the constitution 1982, which part you are mentioning, same thing. So that could be a good intro here. Of course, you can write something else also. Anything with that is dealing with amending procedure, you can start your answer with an introduction. Introduction, don't write introduction on the sidelines and then you start writing in the Canadian Constitution there are two constitutions like that, and don't write boring answer. Okay, be very specific. One line, two liner intro to the concept, that is sufficient. Okay, that is totally up to you. It is your choice how you are going to write. But immediately after that, 2 lines. Don't write entire paragraph over there. 2 lines, then you are coming in the instant case. Jump to what is happening in your case. Now I am writing brief facts of the case. What happening in my case? Brief fact. Only, see, out of that entire one-page fact, I have taken 3 lines. I'll tell you from where. Bill C-22 proposes to change the formula in the Constitution Act 1867 that determines the number of seats each province will have in the House of Commons. This sentence is from here. Bill C-22 proposes to change formula from here to here. This is the sentence I've written there. I just cut this part. Currently before House of Commons doesn't help me, right? So I'm just mentioning what is this bill is about. Okay, then more specific, be more specific what it is dealing with. The amendment is focusing on maintaining the principle of representation by population by replacing the exception. They are not changing the main point. They are not changing the rule, right? They are changing only the exception part in section 51 Constitution Act of 1867 to better suit the principle. They said it. It's there in your facts, right? In the second portion, they have said they want to. What is it about? They have said here. So gist of that. And about the third paragraph, in order to better suit the principle, they are changing this. It will better reflect the principle, right? I've just changed it slightly. An entire paragraph, I've sentenced it one line. So that is what, again, 2 to 3 lines maximum, write about the key facts that is going to happen, helpful in writing the answer. Do not write the summary of entire, facts. So why this helps you in your answer, because they say that in your syllabus also, what are the key points they are looking for you in the exam, whether you're able to identify the facts. Okay, whether you are able to identify the fact. Here somewhere they have mentioned here in my class, I've already told you somewhere. Okay, here basically you have to identify the facts, identify the legal principles, then write your answers, right? So here we have done the same thing. We are showing the same thing, that we have understood here exactly what are the crux of the matter. That's what we are writing in two lines, 3 lines, 4 lines, maximum 4 lines, enough, sufficient. 4 sentences, sufficient. Go ahead. This is your exact answer now. Then immediately after that, you should have legal rules application, case law application, test, your analysis part, everything is here onwards until your conclusion. Before going to detail about analysis, I'll come about conclusion. Conclusion have to be very simple, direct answer to the issue. See, even sometimes I do this. I don't write the entire analysis. Before writing entire analysis only, I will write conclusion first, because the sentence is like, it will be like very difficult otherwise to go front and back afterwards, right? So what I do, I write my issue. Here it is, issue. I write my issue. For this issue, answer should be direct. So in the analysis part, because already I've seen the pointers, right? So I have an idea of exactly which one applies in my particular case. So here the answer is general amending formula. I know that, but I could be wrong. So you can keep a underline, just keep a blank here and write the remaining part. So this is you can use this formula format to write your start your conclusion. Therefore, in the light of the above analysis, in my view, that's what they asked in the question. So always use the same wordings they have asked for your final question, the main question what they're focusing on. So that is also one other tip I would give you, that use the keyword when I say these are the keywords, not like by pop. That is not the keyword I'm talking about. I'm talking about very, very simple thing. What they're asking you in that question, use those words so that they understand that you understood it. In my view, the legally correct amending procedure to be followed or applied to amend the exception provision to the representation by population in section 51 is amended by dash. I'll write it dash and then I'll go continuing with my application. Okay, so here the final answer part is here. So part 5 of the Constitution Act 1982 provides 5 different amending procedures. Oh, it only takes one liner to write. It's not that I will waste so much time in writing, about what and all procedures are there. I don't have to write because they know I have the notes. They also have the notes. They can refer what are those 5 different amending procedures. They do not expect you to write. This is for 20 marks. You don't write. Okay. And amending procedure question usually will be the smaller one only. So just keep it very crisp and clear. There are 5 different procedures, okay, in the instant case. Now, in the instant case, which one should apply? In the instant case, what was the first question that they asked? The federal government is taking the position that, again, fact matter only I'm talking about. Fact, this is from your fact only. They're saying federal government is taking the position that the bill C-22 can be enacted by parliament alone without the consent by any of the legislature. Now I'm giving my answer now. That is why I've underlined it. So federal parliament could do so by citing section 44, which provides for an amending procedure where the federal parliament can exclusively amend. They alone can amend. So I'm saying exclusively amend the constitution in relation to executive government of Canada or Senate and the House of Commons. This is from your notes. In notes, we have already summarized the section. Then why not use that? From your notes, you can write as it is, okay, in your answer. So here we have already summarized the section. We use it. So as it is, I wrote here. Then, however, so other side is also there. However, this much is sufficient because they only asked you to cite. So here we are citing. However, members of the opposition have argued that Bill C-22 cannot be enacted. This is the same sentence that said. Now, we will say that, yes, the provincial legislation can amend the constitution by this procedure under general amending formula stated in section 38,42. Okay, procedure is stated here. And 42 talks about subject matter, that I have to say. So now I am specifically saying under which subject matter it falls under. Section 42 specifies that the amendments with respect to principle of proportional representation of the provinces in the House of Commons must be made using the general amending formula among other matters. Now, till here it is there in your notes. What is this among other matters? Under section 42, it is not the only one. Like unlike what we saw under 44, 44 only one liner was there. It was talking about like 2-3 points, right? Still here also, there are 5 other points. So it's always better to be very clear in your answer. Like you're not saying that only this one it does, even though you're not telling directly, but indirectly it should not be assumed, right? And by doing silly, silly impressive points like this will help you in, getting complete answer, complete marks for this particular question. That's what, this is called as, drafting skills, which you will get by practicing more and more and more. Okay. So starting, you might be writing only till here. So later on, when you become, little experienced in writing answers, then you'll start using other, what other points are there, how to, utilize that knowledge that you have. Yes, there are other points also. So I will be just writing 3 words extra among other matters. Now, in here, I gave what are the two sides, right? 2 sides I gave. Now they are asking about my opinion or my view. They asked correctly what is the, legally what is the correct provision. That I have to support. Now, as provided under section 44, the amending formula of the federal parliament alone is subject to section 41 and 42. I told you we can rule it out, right? Section 44 is actually subject to 41 and 42. Now, what is this? Where is this mentioned? It is mentioned in your Bear Act, which we will be discussing in the class. Like it is mentioned in your Bear Act. Okay, so it in your Bear Act they say that 44 will be subject to 41 and 42. That means any topic under 44 is already covered under 41 and 42. Then federal parliament should not, try to snatch that particular power to make rule on that particular subject. So it is subject to 41 and 42. Always 41 and 42 over 44. Therefore, section 44 is ruled out in this instant case. I use in my answer writing, I use words like this in order to show that I am writing it in live. I'm I'm not copying from anywhere. I'm not taking, if you take out, if you refer any ready-made IRACs, or like if you refer any well prepared, I'm not saying they're bad, they're well prepared, having advanced English, um, structured answers. You take that particular line, and some other person who's also writing along with you also writes that particular line, and the evaluators, they have seen this particular sentence so many times, they'll be then, they'll be under the impression that this is a boilerplate answer. So simply, why do you are spending your hours and in preparation, then 3 hour in that particular pressure, you're writing the answer, finally to get what? You have to get passed, right? That is our goal. We have to clear the concept, clear the paper, and not look back at this again, right? So that is the reason why try to write very simply as possible. Try not to copy from anywhere where it is ready. But in this process, in this course of time, we are going to have you are going to end up with your own answers, which you can copy in that particular day, exam day, which you can copy, which you can use, and you will be saving a lot of time, because you already know the structure. Is topic ka itna hi likhna hai, is mark ke liye itna hi likhna hai. You will have that ready with you. You don't have to think, okay, is topic ke liye main kya kya likh sakti hu. That is not needed at that particular time. Thinking time saved. Instead of that time where you have to spend in reading the question, because question is separate, question is different. So you have to identify, mera ye question tha in practicing. Now, what are the difference between my question and here? Like, what is there in the exam question? That is what you have to focus on. Now, here what happened then, in my opinion, I am writing, in my opinion, section 42, subject matter applies and amendment shall carry out as provided in section 38. Okay, from here also you can stop. Okay, that is sufficient. But I just wrote what is this procedure talking about, as it is from our summary notes, section 38, what we are talking about. Because in the question, they only spoke about 2/3 provinces and 50% population, na? So this part was not mentioned in the question. So I wanted to mention the entire procedure. So I'm writing entire procedure. That is totally fine. You can write it. But it is a summarized version, right? So you can do that. Then what you can do is, yeah, then you can also write little more about that. But that is up to you. You can use your own sentences with respect to, how this particular general amending formula is used in that particular situation. Not required, not compulsory, but everybody's answer is unique, right? So you can add a few little more lines with respect to what is your opinion with respect to this particular provision. What else do you feel necessary to put in that particular provision? About 7 provinces you want to write, about any population related you want to write. For example, in your exam question, if they're asking about time frame, then time 39 also you might write. So in this particular question, not required. So I've just written about a province that does not agree with an amendment affecting the provincial legislative powers or proprietary rights or other privileges can dissent from it, and also by how they can dissent by resolution. In that case, the amendment has no effect in that province. After that last necessary resolution is passed, the governor general can make the amendment by proclamation. So this is like kind of putting an end to that particular entire procedure that we can write, but not necessary. You can stop your answers right here. Okay, you can stop your answer right here and write a little bit, in general about that particular amending procedure if you would like to. Then finally, you know the answer now. You can fill this particular formula, the blank that you had left, and you're done with your IRAC. Yes, Varsha?
Vidya, like you said, so we can just strictly stick to 38 and 42, right? Like instead of mentioning the province will dissent from the amendment if they want to opt out, those are extra pointers, right?
Pointers, but I would suggest that write some, I always say, keep a moist sandwich, don't keep a right answer, very, very dry answer, okay? So in order to do that, like, you have written the exact answer, but wahin pe chhod dena doesn't look that good. तो इसीलिए few more sentences if you write, in general, that is already there in your notes. You can choose anything with respect to that particular topic. अभी यहाँ extra points इधर था तो मैंने यहाँ से निकाला. But if it is related to any other concept, any additional points are there, you can write that.
Okay. And Vidya, you have sent this material to
Yeah,
us?
I have sent you
Okay.
in the mail. So it is उसका नाम होगा amending procedure sample answer.
Okay. Okay. Thank you.
अच्छा उधर कैफे पे ही हो ना?
Yeah, so this is with respect to today's session. We have went through the class schedule, and we briefly saw our syllabus. That much is sufficient for now. Anyway, we are going to in detail, understand each and every topic. So till now, I just wanted to have an picture about how many chapters are there, how many parts are there. When I talk about DOP means what it is, like that. So I would expect you to watch class recordings, at least one per day. Have that particular format of watching one recording per day, and immediately reach out to me if you have any doubts. Within 24 hours, I'll try to reach back to you with a clarification on that particular doubt.
कैफे पे आते हैं, ठीक है?
So Vidya, we'll be practicing. I mean, we have to practice our questions by next week, right? After next week's session, right?
Yeah. So next week's session, we will be practicing question in class, and we will be, summarizing the topics also. Like we'll be
And then we
discussing.
can type it and we can send it to you also, right? After the class.
After the class, you can completely write your answer in your own way, in your own pattern. Like, of course, IRAC pattern, but आपका own sentencing format and all. So that will not be shared with each other. So that in class, whatever I show, that is an abstract. So उसको और आप better करके अपना sentences वहाँ पे mix करके rules might be same. Okay, part will be of course same. Issue will be same. Conclusion will be same. Analysis is your art. Analysis is your part. What you're going to usko articulate kaise karenge, it's on to you. So that part you're going to improvise, because finally in this course of time, you should be able to be developing that particular art of writing analysis in a very beautiful manner. So drafting is what we are going to learn along with the concepts. ठीक है? So thank you so much everyone for joining today's session.
Thank you, Vidya.
Thank you.
Thanks, Vidya.
It's very nice. Thank you. Thank you, Vidya.
Thank you, Vidya,
Okay.
for a very nice session.
Thank you.
Yeah.
Bye.